All right, so thank you so much. And then let me just quickly check if you can see my screen. Just give me one more minute. Sorry.
Yeah, don't worry. Yeah.
Yeah, I think that's kind of easier, right? Okay, so thank you so much. So today I would like to present our ongoing research regarding the institutionalization of the transatlantic data privacy regime from the perspective of institutions and ideas, which essentially relates to the normative underpinnings of this process, and then also interest behind that. So here I would like to give you a quick outline regarding the structure of today's presentation. So first of all, I would like to just briefly explain and also trace the evolution of the institutional frameworks that governing the EU-US data flows and data privacy, which actually has been undergoing a process of, ups and downs, and also there are a lot of ongoing challenges behind this very long and also ongoing process. Then I will briefly talk about the rationale behind the EU's and also the US very different approaches to data governance. And by looking at, for instance, the common interest and normative commitments behind that. And in the very final part, I would like to just briefly talk about to look at the future scenario of the transatlantic data privacy regime. So we can potentially ask a few questions. For instance, to what extent the US and the EU are moving towards greater convergence. So I think that is a question that remains kind of underexplored at the moment, but of course, because things have been developing quickly. So in the final session, we can look at, for instance, the extent to which the European Union really managed to exercise its regulatory power and really effectively diffuse its norms and regulations in the case of transatlantic data flow. So to start with, I will start by looking at the institutionalization of the transatlantic data flows. So first of all, we would like to highlight that the transatlantic relations in data flows and privacy has always been a very interesting case study of the EU-US relations. And I think many scholars also would argue that it also represents a very interesting shift towards innovative forms of transnational data governance. So when we look at the whole process of institutionalization, I think it cannot be really considered as a linear and also a very smooth process, especially given the fact that data flows and privacy actually has long been a sticking point and also a source of tension in transatlantic economic and security relations, especially if we compare these particular policy area with other spheres of economic and security relations. So I think we found that the institutional building in terms of the US-EU engagement in data flows and privacy over the past 3 decades have been really characterized by a very dynamic interaction between setbacks and adaptation, and then also innovation. Perhaps we can try to look at the trajectory of institutionalization from these two different phases, we would say. So if you look at the first phase of development, it essentially revolves around the concept and the adoption of safe harbor agreement. So in this phase, we can see that the early attempts to strengthen the EU-US institutional relationships on the issue of data privacy can actually be dated back to the late 1990s. So the negotiation over the safe harbor agreement can be regarded initially as a direct response from the US to the European Union's internal institutional development in data governance. As we can see in the EU's adoption of the 1998 Data Protection Directive, that basically constitute the foundation of the European Union's data privacy regime. And we can see that it also laid the foundation for the European Union's GDPR, right? So in this 1998 directive, the European Union specified a set of conditions under which personal data could be transferred to non-EU countries. So in order for those data to be transferred to non-EU countries, the European Union require an adequate level or a good level of data protection in third countries. So here comes the starting point of the negotiation, because back into that time, the US did not have any sort of comprehensive data regulation framework at domestic level. So the US Department of Commerce then proposed to establish a self-regulatory mechanism which would allow the US companies to be sheltered from the sanctions derived from the EU's data privacy directive. So that kind of negotiation ultimately resulted in the Safe Harbor Agreement, which was adopted in 2000. And that agreement arguably functioned quite well for the next around 15 years. But then we can see that there was the first, or we would argue the first major turning point, which was the fact that the Court of Justice of the European Union struck down the Safe Harbor Agreement in 2015. So after 15 years of the adoption of the Safe Harbor Agreement. And perhaps some of you might be familiar with the rationale behind that, but the key reason behind the Court of Justice of the European Union's ruling was a result from the Snowden leak. So that the European Union had increasing and also huge concerns over the US National Security Agency's surveillance. So the concern behind the European Union at that time was not really about the commercial data transfer, but really centered more on the US government's mass surveillance. So following the very famous Schrems I case, the Court of Justice then invalidated the Safe Harbor Agreement. So I think it's quite interesting to know that these external shock that typically would result in a major kind of shift or sometimes the failure of institutionalization did not really, for instance, result in the complete stagnation of the negotiation between the EU and US. But we would see this Court of Justice ruling as a starting point for another round of negotiation and also another round of, I would say, innovation in terms of the transatlantic institutionalization in data privacy. So then we come to the second stage, which is more about the, after the innovation, the negotiation, we have the privacy shield that has been adopted in 2016. So the privacy shield largely mirrored the self-certification approach of the Safe Harbor Agreement, which means that the institutionalized dimension still remains relatively weak. And very similar to the Safe Harbor Agreement, the privacy shield function based upon, again, a unilateral actions by the EU and the US, rather than really serving as a kind of conventional forms of treaty or international agreement. And the privacy shield principles are essentially an expansion or a kind of expanded version of the safe harbor principles. So then I think here we have the second major turning point, or the second external shock, which is after 4 years of implementation of the Privacy Shield, another kind of major shock to this transatlantic data privacy regime occurred. So in July 2000, the Court of Justice of the European Union again made a ruling in the Schrems II case, and once again declared that the transfer of personal data through the Privacy Shield was illegal. And then the court again determined that these did not really offer the adequate and necessary level of protection to comply with the EU standards after the introduction of the European Union's GDPR. And the ruling was based on the extensive scope of US data collection through, again, government surveillance, and the lack of options for EU citizens to seek redress. So even though in the second phase, the Privacy Shield attempts to address a number of concerns raised by the Court of Justice in the previous round of ruling, but still it has been regarded as really insufficient to meet the requirements of the Court of Justice after the implementation of GDPR. So now I think we are entering into the third stage, which here you can see the phase 3. So from the previous kind of EU Court of Justice ruling, and again following more than 1 year of detailed negotiation between the EU and US, which basically were led by the Secretary of Commerce and then also the Commissioner for Justice in the EU. The European Commission and the US recently announced that they have agreed in principle on a new transatlantic data privacy framework. So here is termed as the TADP, which will continue to foster transatlantic data transfer, and also to continue to tackle the concerns raised by the Court of Justice of the European Union in the Schrems second ruling. So now, at the time of writing, and again, this is still a kind of ongoing process, and I think it's really expected that the next step would be for European Data Protection Board to issue an opinion, and then the decision will finally need the approval from a committee of EU member states representatives before the European Commission can really vote on the formally adopting the draft decision. So there is still a lot of kind of further steps to go before the agreement can really come into effect. So as we can see, after tracing this whole process, we note that it's really a very turbulent process. But I think the fortunate thing is that both sides still have strong commitment and also willingness to continue the negotiation and take things forward. So I think this, I would say it's something that interests us as researchers in, for instance, in terms of institutionalism and also in terms of policy change. Because typically we would expect that multiple external shocks or multiple kind of critical shocks to the process of institutionalization would typically result in either major shift in the institutional design, or in terms of, that result in a complete failure of the negotiation. But obviously that didn't really happen in this particular case. So that's why we want to trace and we want to really understand the dynamics behind that. And especially because within the literature on institutional change and within the broader debate about institutionalism, there has been a long-standing question, for instance, what factors that really drive institutional change and the further institutional innovation. So I think we kind of try to follow the existing scholarship on these topics that share a broad consensus on three major elements. For instance, we can try to look at the interest, either common or divergent interest behind the efforts of institution building. We can also look at, for instance, ideas that is essentially about the normative underpinnings and the ideational factors behind that, which we will try to unpack a little bit in a few slides. So we believe that both these factors play a very significant role in driving the process of negotiation and institutional innovation forward. But then I think ultimately we also will need to pay attention to the normative gap, especially in the domain of transnational data governance in the EU and the US, to really fully unpack the frictions and the challenges behind that. So I will briefly go through the interest dimension between the institutionalization attempts. So this can actually be quite intuitive, because when we look at the economic benefits behind these efforts to further institutionalize the transatlantic data privacy, data flows and data privacy regimes, it's really concerned and also derived from the economic considerations. So the economic significance of data flows between the EU and the US is extremely profound. So to give you some data, for instance, the trade and investment between US and Europe basically value at more than 7 trillion US dollar, underpinned by the digital data flows between the two. And in 2020, for instance, Europe was the United States' main commercial partner in the digital economy. And then the US registered a surplus of 105 billion US dollar in the trade of digitally enabled services with Europe. So also about 46% of US digitally enabled services were exported to EU countries, while about 45% of those services was imported from across Atlantic Ocean. And the trade in digitally enabled services between the US and Europe was much more than US digital trade with the rest of the world. So I think that can basically provide a good explanation regarding why both sides, despite ongoing challenges and the very kind of turbulent process, they still try to push forward for these negotiations, and they really want to keep the institutional links working. And I think on top of that, we can definitely identify some normative considerations behind that kind of common position. For instance, we can identify common normative commitments to the free flow of data. And we obviously can see that in the case of the United States, this commitment to free flow of data, basically it has a strong emphasis on the maximum possible free flow of cross-border data. And then its intention to ensure that regulatory differences between the countries will not become substantial trade barriers. So that is the US position on the free flow of data as a basic principle that is reflected in a number of bilateral and also regional free trade agreements that has been signed by the US and its key trading partners. And I think here are just two examples, which is the free trade agreement between the United States and South Korea. And that was one of the first agreements that targets data flow, for instance. And the other example is the more recent trade agreement between the 2020 United States, Mexico, and Canada Agreement digital trade chapter that really makes the US commitment to this principle much more explicit. And speaking of cross-border transfer of information by electronic means, including personal information. So we notes that in the case of the European Union, and I think we can see that in the EU's strategy for data, which was released in 2020, the Commission has explicitly pointed out that data is essentially for economic growth, and the innovation and societal progress, and then a series of initiatives of the European Union have been put forward, including the regulation of framework for the free flow of personal data adopted by the Commission, that attempt to remove the barriers of data flows within the European Union. And then other examples and initiatives include Open Data Directive of 2018 that addresses more specifically obstacles to open data and reuse of public sector information. And more recently, I think the Data Act, which was just adopted last year, so is highlighted as an important step forward towards building a genuine single market for data, making more data available for use in line with the EU rules and values. So we definitely see that at the overarching level, both the US and the European Union, they kind of try to commit themselves to this idea of free flow of data, as opposed to some, I would say, approaches adopted by some other countries. And one example is, China and Russia. These countries actually prioritize a much more, I would say, a sovereignty-based approach towards transnational data governance. So, however, despite its acknowledgement of the importance of free flow of data, the European Union has been rather cautious with regards to the inclusion of provisions on the free flow of data in trade agreements. So this is slightly different from the US approach, because it demonstrated wish to couple the issues of data flows with the high data protection standards. So here is what we call a conceptual or a normative gulf between the European and the US in terms of their respective approach towards transnational data governance. So despite their shared commitments and the huge economic incentives behind these negotiations and behind these institutionalization attempts, there has long been a conceptual gulf or a normative gap between the EU and US with regards to data governance. And I think this gap primarily derives from very different conceptions of individual rights prevalent in the US and the EU. So, for instance, for the European Union and under the European Union law, data privacy is the fundamental right protected at the highest constitutional level. So, such as being codified in the Article 7 and 8 of the EU's Charter of Fundamental Rights. And the right to privacy is also kind of codified in Article 8 of the European Convention on Human Rights. So for the US, I think the US data privacy law is really underpinned by the marketplace discourses and really views the individuals as trader of personal data, and understanding governmental protection in a marketplace as a kind of a form of unfairness. So another kind of in this slide, you can see that the conceptual gaps between the EU and US in terms of data governance also derives from their very different understanding of the relation between market and state. So I think for the European Union, the EU has historically been more suspicious and also skeptical of the market's capability to self-regulate, and therefore more comfortable with a stronger regulatory approach. And I think that is evidence in many of the European Union's policy areas where the EU as a supranational body has, for instance, full competence over competition policy. And I think the very kind of strict and a very strong position of the European Commission in competition policy to basically ensure the kind of fair trade among different parties. I think that also generate a lot of frictions with those high-tech companies such as Google from the US. And looking at the US, I think the American approach to data governance is primarily driven by the rationale to really boost the technology sector's growth. And regulators have therefore really kind of relied on market self-regulation and intends to adopt a kind of hands-off the internet approach that is, rather limited forms of governmental intervention. And I think these kind of conceptual gulf and these conceptual and normative gap can help us to understand why the process of institutionalization has been really challenging and also is not really, smooth in comparison to other transatlantic cooperation. So in the final slides, I would like to just talk briefly about, the potential future scenario of these transatlantic data governance regime and the extent to which the European Union and the US are traveling towards greater level of convergence. So here in this slide, I would like to show you like two very interesting recent dynamics and new developments. So for instance, in October last year, the US President Biden took a very kind of, especially in the perspective of the European Union, Biden took a very critical and crucial steps and issue an executive order that is entitled Enhancing Safeguards for the United States Single Signals Intelligence Activities, which basically tries to provide enhanced legal safeguards with regards to the use of personal data by the US national security agencies. And I think this executive order established that the US government agencies are only permitted to collect data and that is deemed essential and proportional for civilians operations conducted by these national security agencies. And that has been regarded as a unprecedented legal changes that implements US commitment under the TADF framework. And despite the fact that this is an executive order, that is an kind of internal directive and is not a law statute, this reveals the US has taken a tremendous step toward the EU from a political point of view. And I think the second very interesting dynamic and also a kind of new development from the US side is the United States proposal to establish a federal level Data Privacy and Protection Act. And this idea was proposed again last year, back into the summer last year, that represent the first federal privacy bill with bipartisan support for more than a decade. So basically, in I think it's a typo. I think it's back into last year again. These ADPPA passed a committee vote and then made its way to the House floor. And that means that this attempt at passing a national privacy framework in the US is one of the closest attempts that there has been. And of course, there are still several ongoing kind of hurdles to overcome before that can really be considered to stand a legitimate chance of becoming a law. But I think at least that indicates some forms of developments, especially since, again, coming back to this third kind of phase. So I think there are a couple of discussion at academic and also policy level regarding the extent to which these new developments, either in legal term or either in political stance from the United States, actually shows that the European Union is trying to export and also exercise its regulatory power, or externalize the so-called Brussels effect in transnational data governance, and then ultimately play a role in incrementally changing or even shaping the domestic legal frameworks, or legislative attempts within the United States. So I think there are a lot of hope that the United States and the European Union will ultimately work towards higher level of convergence. But again, I think the whole negotiation and whether the European Commission will finally approve these the new version of data privacy institutional framework remains to be seen in the perhaps upcoming month. Yeah, so I would stop here, and that's all about my presentation.
Wow, thank you. I think this was a really comprehensive presentation on data privacy. I don't know if someone in the public back there in Washington has a comment, a question.
Yeah, any comments or questions are very welcome. And again, this is just one ongoing research, and any feedback or comments would be really welcome.
Awesome, thank you. If no one wants to add something on that side, I got one question.
Yes, please.
I write it down and at the beginning, so I think you already talk about that a little bit, but I will repeat it anyway because probably it changes the focus.
Yes, sure.
Thank you. I think it was a super interesting topic to talk about and research about. I was wondering how this transatlantic relation between the US and the European Union affect or modify other data policies in the different geographies, let's say in Latin America, in Asia, how that impacts.
Yeah, thank you so much for that question. So I think first of all, for instance, if we look at the so-called kind of regulatory power of the European Union, for instance, we can definitely see the spillover effect of GDPR already. So because I think even in the case of China, I think it's newly adopted data privacy legislation, and many parts of those actually mirror the content of GDPR. So, and I think another example is that when the European Union negotiates its trade kind of economic agreement with Japan, for instance, again, in the Asia Pacific region. And I think, again, it's very similar to the case of, EU and US negotiation, because basically the European Union requires Japan to develop adequate level of data privacy law at domestic level in order to really, include data free data transfer between the EU and Japan. So I think ultimately, if I remember correctly, I think back into 2018, and I think Japan kind of agreed to make some kind of amendment and also adjustment to its domestic legislation in order to comply with the European Union standard. So I think in that regard, we can definitely see how the European Union's own data privacy regime already had the kind of external dimension. And I think that comes back to the whole idea about the European Union's soft power or regulatory power as a global kind of a big trading bloc, and more increasingly in the sphere of data and digital economy. But I think coming back to like your question regarding, for instance, how the transatlantic data regime is impacting data governance or digital trade in other parts of the world, I think that again remains to be seen. And I think first of all, because the level of institutionalization remains rather weak and modest. And then I think secondly is because perhaps, as I just mentioned in one of those slides, that the European Union and the US are adopting slightly different approaches with regards to data transfer and data flows towards countries outside of their own kind of territory, whereas the European Union really, even though also commits to the free flow of data, but I think the European Union prioritizes the fundamental rights of privacy. So it's much more cautious when negotiating with third countries with regards to data flow, whereas I think the US is much more flexible and has a relatively limited kind of these restrictions with regards to data transfer with third countries and regions. So yeah, so I'm not entirely sure whether I kind of answer your question, but I think so throughout this kind of case, I definitely can see that the European Union is really exercising a greater level of kind of regulatory power incrementally kind of beyond its immediate border, and then to influence some data privacy legislation in countries even in Asia Pacific region. So I think in that regard, I think this is quite a tremendous achievement.
Wow, thank you for your answer.
Yeah.
And anyone else wants to raise a comment, question? I think, yeah. Please go ahead.
Thank you so much for your presentation. It was great and super informative. My question is about if you dived at all or saw in your research anything about like sector specific differences. So like, for example, health in the US, we have like HIPAA that covers some health data, but not all of it. And then in the EU, it's all GDPR. And now they're kind of exploring more like health specific data protection. So I was wondering if you could speak to that a little bit. Thank you.
Yeah, thank you. Thank you so much. So first of all, thank you so much for your comment. And I have to acknowledge that we have not looked into that kind of level of details yet, but we definitely pay attention to the fact that, for instance, in if I understood correctly, I think in the US, the data governance framework or the kind of legal infrastructure of data regulation is much more sector driven. And then I think it's essentially at the, it's not at federal level, but more at the states level, if we understand kind of correctly. And I think, as you mentioned, it's very interesting to look at, for instance, how the US, for instance, adopt a very different kind of sector-driven and also, I think, more a kind of self-regulation approach towards data governance. And then, for instance, how that kind of difference can also potentially be a hurdle for a harmonized approach of transatlantic data governance. But we will definitely look into that part of research, but we have not been there yet, given that this is, some kind of early and preliminary reflection of the project. But thank you so much for giving your comment on this, and we will definitely have a look at this, and hopefully we will share more research outputs and preliminary findings at a later stage. But thank you so much for pointing this out.
Great, thank you.
So I guess that will be it. Thank you so much. And I don't know if you want to add some final remarks on it. Yeah.
No, I think, yeah, everything is good. And thank you so much for being here, and then to be the moderator, and then for listening to my presentation.
Yeah, of course. Thanks to you. Thanks to all the.
Yeah, and thank you. Thank you for the lady in Washington. Thank you so much for attending the session.